Yes. Can I help you, Ms. Davenport?
Good morning, Your Honor. It's actually Mr. Davenport. I wanted to address a discovery issue with a preliminary exam I have upcoming.
Have you talked to the prosecutor?
Yep, I have.
What is the exam and who are you talking about?
The exam is actually today at noon. I have been discussing it with the prosecutor. I want to see if we can go on the record, but it's for Javion Lawson.
Okay, so what's the issue?
The issue is that over the course of this case, we have submitted our discovery order, gotten it signed and submitted, and we have been in communication with the prosecutor. However, we did not receive any discovery until sometime this morning, I believe. I haven't been able to review it, and
You received it when?
I'm sorry. Say that question again.
You received it when?
Sometime this morning.
They sent it sometime this morning. We didn't see it until.
But yeah, I didn't know that she sent it until later on this morning. But without adequate time to be able to review it, discuss it with my client, or anything like that, we have enough time to prepare for this preliminary examination.
But that's not all the discovery anyways.
Yeah.
That's on the video. You didn't get the lease agreement either.
I understand.
Do we even know that this exam would go? If they're gonna have a complaining witness?
Actually, we have been in communication with the prosecutors. We don't think the complaining witness is going to show up, but instead of driving down there and showing up in person for a just in case, I prefer to get it dismissed on this ground so that I don't have to drive down there or appear in person.
It'll probably be highly unlikely for me to dismiss it. The lack of discovery that you received today, although it's late.
It's not all the discovery.
Well, Judge, we also were seeking the lease agreement. I wasn't actually at the hearing, but the last hearing, Ms. Shabazz stood in for me. Ms. Shabazz Davenport stood in for me. And the prosecution said they were going to obtain the lease agreement for the preliminary examination. We also did not receive that either at all.
And we don't even know what discovery was.
Okay. So why wasn't it possible for Ms. Davenport to try to get that lease agreement?
Judge, I'm right here also. I was on the record last time at the hearing, and I already informed the court that a subpoena would be required and have to be signed by the court. And the court inquired with the prosecutor, who indicated to the court that she would actually obtain, and she said that she would do whatever she needed to do. She said she didn't think that it would be an issue. So that was that. I've been in communication with the prosecutor. I sent over my discovery order and everything else. The prosecutor from there, I guess she was not able to obtain the lease agreement. She did not bring it to the court's attention, how the court requires for any issues to be brought to the court's attention ahead of time. It was not brought to the court's attention. She emailed me, asked us if we can inquire with our client. We informed her again that he was in custody, but we would try to set up a jail visit. We set up a jail visit. It wasn't able to be done until yesterday, in which case we spoke with our witness or whatever. I'm sorry, our client, and he informed us of the address, but it's the same address that the prosecutor already knows. She just didn't know the apartment name. She couldn't get in touch with her complainant or any of her witnesses. I guess she didn't drive down there or anything else, like how we would be required to do when we're trying to seek discovery. But we did everything on our end that we could do, Judge, in so little time. But we do have a discovery order where the court actually signed for the prosecution to turn over all of this discovery, and it hasn't been turned over. And I don't even know what is even included in the email, because we just noticed the email about an hour ago because we were handling other stuff as far as for our cases and everything, which is why we don't try to wait till the day of to even receive our discovery. We got other stuff we have to do. So we noticed it about an hour ago. We were not able to download it because it looks like it would be a lengthy file, and we have a separate computer for that. But that's why we're trying to log on now to inform the court. So we don't even know what's contained in that email, or if it's even the videos or anything that we were seeking. But that's why the prosecutor is required to actually send it the day before, like before, not hours before the exam. I'm sorry, I don't think that's my my device, but I'm hearing like a gaming or something.
It's a tether going on.
Gotcha.
On the defendant that's in the courtroom.
Understood.
Can you have Ms. Train step in? So the only discovery you're missing is the lease agreement?
I can't say that, Judge, because we don't even know what was sent in the email. There was an Exxon file that was sent. It looks like the timestamp on it was about 8:30 or so. And we just noticed it about an hour ago.
You know, if the lease agreement is included in that, do you?
Because it's videos, Judge, but also Ms. Drain already indicated to us that she wasn't able to get, as we mentioned, we've been in communication with Ms. Drain. So on our end, we've been communicating with her, and she wasn't able to obtain the lease agreement. And I see she's nodding her head yes right now, so sounds like she's concurring.
Yes, we've been in contact, Your Honor, and I have tried to get what I can. I do not believe that the plan is going to appear, so I think all of this is rather moot at this point.
Judge, I don't want to keep on saying this moot because wait until the last hour. I mean, I'm not trying to put it off on Ms. Drain. I understand that she has to work with her colleagues and they have to get the discovery over, but we're doing everything the court is requiring of us. We submit the discovery order in a timely fashion. We communicate with the prosecutor as the court requires.
She said it's a moot issue because the complaining witness is not going to show.
But it wouldn't be a moot issue regardless of the complainant showing or not, really, because that's a separate issue. It's not really moot. We're doing everything on our end. We're doing extra work to get this discovery, and then we have to wait.
Case is not going to go.
You said, what's that, Judge?
You want discovery on the case that's not going to go.
Not even that we want discovery on the case. Judge, what is the remedy? Because it keeps on happening. So rather than wait until the last hour or even having to wait hours before to get the discovery and then say, well, you got the discovery, what can you do?
One at a time. I'm talking about this case.
I'm talking about this case also, Judge.
Discovery on the case that's not going to go. Is that what I'm hearing?
Can you say it again?
For the fourth time, we want discovery on a case that's not going to go.
Let me choose my words. I wanted discovery on the case that was scheduled for a preliminary examination at 12 o'clock today. Well, we don't know if it'll go, because what if the complainant just so happens to walk in? Rather than waiting last hour and we keep on doing this.
Okay, please don't talk over me.
I'm not going to talk over you, Judge.
He's still talking over me.
Well, you're cutting me off.
When I talk, you stop. Understood?
No, I actually don't understand that, Judge.
Why don't you come down here and I'll make it clear to you. Come down. I'll see you at 12 o'clock.
I'm not coming at 12 o'clock, Judge.
Okay, don't come then and see what happens.
Okay, so do you want Attorney Davenport, who is the attorney on this case? Do you want to speak to him? Because if you're asking me,
why are you even talking to me if you're not on this case? I don't even want to talk to you then.
Well, you asked a question about me, Judge, so I started speaking.
You're talking to me if you're not involved in this case.
Well, I am involved. I'm co-counsel on this case, Judge, but just to be.
I want you to come down here at 12 o'clock today.
I won't be coming, but here's Attorney Davenport.
And I'll hold you in contempt of court.
And I'll go ahead and file a grievance.
Do it.
I will.
I don't appreciate any yelling. I feel like it's unprofessional. I feel like she was trying to express the fact that this.
And I asked her not to talk over me, Mr. Davenport. Just like you stopped when I started talking, I expect the same from her.
Just as this happens in other cases, we expect discovery in a timely fashion so we can represent our clients in the best way possible. So as these cases become moot points of discovery, we would like to be able to have a situation where if the complaining witness does show up, we don't have to wait till the last minute. We can either hold the exam or not. We started off asking for discovery in court. We were told we have to submit a discovery order. We started submitting discovery orders. After we submitted discovery orders, we were told we have to keep in communication to remind prosecutors that we have to get our discovery as they're obligated to provide us with. After that, you told us if we were in communication, then we should file motions to compel. We keep trying to do and be proactive. And we're trying to explain this problem right now, but there's no reason
Mr. Davenport, if the witness was to show up, there's no way I would make you go forward on the case that you just received discovery on today. Period. Now let me talk about what I don't appreciate. I don't appreciate being talked over. I don't appreciate when I'm trying to make something clear. Ms. Davenport indicates that she didn't understand. I told her to come down here. She told me what she's not going to do. I ordered her to do so. So understand that grievance process works both ways. I can file a grievance as well.
And so in this situation where she's trying to get the case dismissed before 12 o'clock because we wouldn't be holding it whether the complaining witness shows up or not, and we're trying to be efficient with our resources.
I'm not inclined to grant a dismissal when discovery was given to you, although it was not given to you timely. I'm not inclined to dismiss based on that.
What will be the future? What will be the remedy for future reference?
What future reference? What are you talking about?
So in any other case, in a situation where we submit a discovery order, keep in contact with the prosecutor, submit a motion to compel, and the discovery
case by case basis, sir. I can't tell you what I'm gonna do in the future.
Oh, okay.
I don't know how to comply.
I mean, so we just have to keep.
You're not gonna comply anyway, Ms. Davenport.
I'm sorry, Judge, I didn't hear you.
You told me you're not gonna comply with the court's order. I ordered you to be here at 12 o'clock. You told me you're not doing it.
Judge, I can't come down there at 12 o'clock today, but when you see me on another hearing, or if you want me to come down on a different time, then we can definitely discuss it in class. In fact, I know that is this recorded? Because if this is recorded, then we both can use it in our grievance. But Judge, you asked me a question. I started answering. You cut me off, and then you said, when you start talking, I stop. I'm not a child. I'm not a puppet. I don't disrespect you, and I expect to be respected as well.
I expect you to respect this court.
I do respect this court, which is why when you ask a question, Judge, I stepped in to answer your questions. I don't like to talk over people either, Judge. It's just that when you ask me a question and then I'm answering it, when you're cutting me off, how do I know if I'm answering your question? When am I supposed to stop or not? If you want to speak, then I will be quiet so that you can speak. And then when you ask me a question, I'll answer your question. Oh, I'm sorry. You want to speak to Attorney Davenport?
Ultimately, Judge, in this situation, which was a similar situation as last week, and I understand it's unpredictable and we can't really determine what you'll do based off past action. But last week, when the complaining witness didn't show up and the discovery issue was moot on a different issue, I appeared in court physically. Now, that wasn't a requirement for the prosecution as they came in on Zoom, and I have no problem with that because it's an efficient use of resources. However, I don't agree that it's an efficient use of everybody's resources if we're not going to hold this exam to have us continue to come show up in person. We're doing all this back work trying to make sure we're prepared. So we prefer to appear on Zoom.
I don't have an issue with that.
Okay, thank you.
The prosecution is indicating that the witness is not going to appear.
Very well, Judge. Would you like us to appear at noon?
That's what time the exam is scheduled.
That's true.
So he don't want you to address discovery issues in advance no more.
Won't be able to tell. Yeah, wait for the next case. Okay, so we will appear back on Zoom at noon for the dismissal. And I'll see you then, Judge. Is there any other issues you'd like to take care of?
No.
Okay, we'll be back. Thank you.